time is 9:03. My name is Christian Waugh. I'm the Special Master for Code Compliance here in Citrus County, and I hereby call this hearing to order. I'd now like to ask you if you join me in standing for the pledge to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
The next item on the agenda is approving the minutes from the August 18th, 2021 hearing. Are there any proposed revisions or objections to the minutes as currently formulated? I have none, and hearing none, I will go ahead and approve the minutes.
Staff update, continued and abated, or the abated cases are posted out front. We don't have any continued this month.
Okay. Ladies and gentlemen, good morning. Again, my name is Christian Waugh, and I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by local law, but all it means is that Citrus County has hired me to preside over your hearing. When your case is called, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, I'll state the alleged violation and allow the county to present its case. You will then have an opportunity to present your case regarding the violation, which may include evidence if you wish. During this process, the county attorney's office or myself may have questions of parties, witnesses, or staff. I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and be made as succinctly as possible. I should note that if you are here and you oppose the county's case, you would have the right to cross-examine any county witnesses. In most instances, if you are found guilty of a violation, the law requires you to be given time to comply before a fine begins. You must abate the violation by that date, that is, fix the violation, or the fine will accrue for each day that you remain in violation. The law then allows Citrus County to impose that fine as a lien on all of your real or personal property, and the county may foreclose on such a lien or seek money judgment against you after the lien has been recorded for 3 months. This is important because I may not give you another date to appear before me, and therefore you likely will not have another opportunity after today to plead your case or to explain why you didn't comply with the county code. The county will continue maintaining its liens until you notify the county of your compliance. In all cases in which I find someone guilty of the violation, I will impose all costs required by the county ordinance or regulations. If you abate or fix the violation in the time allotted, that cost will remain minimal. However, if you do not timely comply or fix the violation, you will be responsible for additional costs as well as the cost of the lien that's imposed. If I find you guilty of the violation and allow for a continuance of your case, you'll be required to return on a certain date. In the time between hearings, I will require that you comply with the county and its code in order to consider the violation resolved. If your violation is not resolved by that next date, I may impose a fine for each and every day of violation from today's date forward. Your failure to return on the date may be deemed evidence of your failure to cooperate with the county. I don't think there are any appeals of orders to demolish. Okay. Ladies and gentlemen, you do have the right to appeal any order that I make here today, as may be provided by law. Thank you very much.
The first case today, Brandy L. Berta. Case number 213-8246, Code Officer Matt Hampton, page 8 of your agenda. Joanna Catu is going to be the expert.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Can you please state your names for the record?
Brandy L. Berta.
Kurt Berta.
Thank you.
Morning.
Morning.
Matt Hampton, Citrus County Code Compliance Officer. It's case number 213-8246. Special requirements for all accessory structures. Violation of Citrus County Land Development Code 3102A. The address is 10432 West Misty Rose Street, Homosassa, Florida. Property owner Brandy L. Berta. I have good service via posting of the property in the Lecanto Government Building. I would like to authenticate the documents and request that they be admitted into evidence. Exhibit A, photos I took during my initial inspection on April 22nd, 2021, photos I took for the corrective action inspection on August 25th, 2021, and photos I took during my final inspection on September 14th, 2021. Exhibit B will be a copy of the property appraisers showing a vacant lot, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit and picture of the posting completed on September 2nd, 2021.
Ma'am and sir, what I'd like to ask you to do is look at the documents that are being presented to you and let me know if you have any objection to them being evidence in this hearing.
Good catch.
No objection, sir.
Okay, and ma'am, do you have any objection?
No, sir.
Okay. Is anyone from the public here to speak on this case? Let the record reflect that there
She's awful nice.
is no response.
Making sure my authority's up to date.
Without objection, what's been proposed as county's exhibits A and B are evidence.
I conducted my initial inspection on April 22nd, 2021, and I observed the property to be in violation for storage and special requirements for all accessory structures. Multiple vehicles, travel trailers, and other possessions were on a vacant parcel. I've had contact with the property owner. She stated that there are squatters on the property and she was trying to figure out how to get them off. I conducted a corrective action inspection on August 25th, 2021. There has been even more vehicles and junk brought onto the property. Notice a hearing was issued on August 25th, 2021, and as of my final inspection September 14th, 2021, even more items have been brought on.
Is there anyone else from the county who wishes to testify?
Joanna Coutu, Land Development Director. This is a residential site. It's Coastal Lakes residential with mobile homes allowed. We have no record of any kind of principal use or residence established.
Or an application for?
Or any applications, correct.
Okay. I show that the property owner is you, Ms. Berta. Are you also a property owner, Mr. Berta?
I am the owner.
Okay. Can you guys tell me what's going on?
So ultimately, we bought the property, or my wife bought the property back in late 2019, sight unseen from the county's list of lands as a vacant piece of property. Unfortunately, when we showed up out there a couple months later and had the opportunity to get out and see what we had purchased, it was not vacant land. It had all basically but the travel trailer you see in the one picture, but the black building and the structure kind of off to the left, and an old boat and literally dumpsters worth of stuff were on the property. As we began to walk around, a gentleman came out of one of the boxes, literally a plywood box, confronted us very angrily and upset that we were on his property. After some research and getting the gentleman to calm down a little bit, it was his granddad's property for 35 years. Somehow his granddad did not pay the taxes on it. Unknown to us, we bought a mess from the county. We have, over the last year or so, tried to befriend this gentleman, not cause a huge scene, send a felon back to jail. He is a convicted felon for the distribution of crystal methamphetamine. He knows where we live. He went on the county's website, found our street address. He is very sure that he told us that. So we're stepping very lightly into what we can and can't do with this gentleman on this property. We have found that his mother owns the land to the left. Directly bordering the property that we now own is his mother. The land on the other side of the property is owned by both of his brothers in the deed from their granddad. So we're stuck in a really nasty situation here in trying to basically, at this point, we just want to get rid of the land. We bought it as a place to store trailers and hopefully put a shed on someday, not this. So we're in kind of a situation, we understand, we have no objection to the pictures, they're real. You know, we have no ability without major confrontation and legal action to clean any of his property off of our land. When we initially received notice of violation, we contacted Scott McKinney. We have been working with this gentleman to sell him the land, basically as a quit claim deed.
Sell who the land?
The gentleman that's squatting on it.
Oh, okay.
Yeah, not
I
Scott,
thought
I'm sorry.
I've heard things about Scott McKinney, but that doesn't.
Don't believe everything you hear, and only half of what you see.
But we were talking to Scott when we got the notice, let him know what was going on. The gentleman that is squatting on it is getting power and water from his mother to this land.
Let me ask you this. So, did you acquire I understand that you got it from, I guess, the county's list of lands, but was it a tax deed sale or something like that?
It was, we
It
did
was-
purchase off-list lands for a tax deed.
Okay, I just wanted to make sure
And
it was a
we do
tax
have
deed
a
sale.
copy of that.
Okay.
Yeah, it is tax deed.
Okay, I mean, that's an interesting
And he-
theoretical point.
When
Okay.
we did try to pick up this stuff off the land, he did threaten to shoot us if
Right.
we came back on the land. And like I said, and then the next time we went out there, he's like, I know where you live. So all of a sudden it's not a good situation.
Well, look, the code says what it says, right? I mean, that's the issue. How much time would you need to do whatever you need to? Look, here's the situation. The property either has to be brought into compliance somehow, or you have to find a way to escape this.
Right.
So really, based on the evidence I have, which is undisputed, there's a violation here, right?
Yes.
So what I have to do is to give you an appropriate amount of time, a reasonable amount of time to bring the property into compliance. Now, it sounds like this is not a 30-day fix. I don't know what other things you may be considering, but how much time? Well, first of all, Mr. Hampton, have you heard anything that you disagree with today?
No.
Okay. You're aware of
I
the
actually,
issues.
one of my visits out there, actually the day that I posted the property, the woman, his mother, was out there, and she confronted me. Now, she wasn't angry or anything. She asked me what the heck I was doing there, and I told her that the property's in violation and I'm posting it for good service. She goes, service for what? I said, all this stuff can't be here. I said, it's got to be removed from the property. Well, this is where my son lives. I'm like, well, it's got to go. And she goes, whatever, and walked off. And then the next day, yesterday, when I did my final inspection, I actually pulled in. The way you have to turn around is you actually have to go to her property, kind of pull into her driveway to be able to back out because it's extremely narrow back there. And there she was again, and she's like, just kind of waved to me like.
Well, the thing about tax deed sales is the county doesn't make any promises about what that property looks like or says. You know, it's kind of, you buy it at your own risk. If you want to sell it with a warranty deed, normally you have to do a quiet title action even, to ensure clear titles. So these are sometimes thorny things. In any event, how much time assuming I did find a violation, how much time would you need to solve this?
Could I ask a quick question before I answer that,
Yeah.
please? And we've got the inspector here. To bring this into compliance without removing anything, is there any way to do that?
They would have to apply for a principal use structure, basically a home. They would have to come in with all the plans that are necessary. They'd have to get it approved by the county and a permit issued to them by the county for them to have the possessions there. Am I incorrect with that?
Well, actually, it's the owner
So-
would have to do it.
Right.
We would
Yeah,
have
and
to do
that's-
that for them to live there.
And that was my thing. I know because we live in Hernando County, they have an RV use where you can permit the lot through zoning for the use of an RV. And I was curious if that's something allowed, but I assume I then have to have power and water on it, which the land has no power and water. It's vacant land, so I don't
Right,
know.
we don't have that ability. You also can't get I heard you here, you want to get the lot for a shed and parking, can't use that way. It has to have a residence on it.
Okay.
So, I mean, they can pull a permit with your authorization, or you can pull it, one or the other.
Okay. What's that?
So what we would like to do, obviously, is do a quick claim deed to this gentleman and basically give him the property for $1, whatever, just to get out of it. What's happened so far is we've talked to him, but he's back in jail every time.
Well, let me stop
To
you
get-
for a second. So
okay.
there's a couple issues here.
Yeah.
Number one is, I really don't want the county to provide legal advice to you during this hearing. This is an evidentiary hearing, and I can't give you legal advice either. So, what I can say is, I don't know if that plan will be successful or not, and I recommend that you consult an attorney about that. Okay, there's all kinds of nuances with quitclaim deeds. For example, again, this is not advice for you to rely on, to be clear, but things that I'm thinking about is sometimes quitclaim deeds can be rejected. So it's theoretically possible that even though you quitclaim deed something to someone, that they reject it, and then you still can't get out from underneath it. So for our purposes today, I don't know if that plan would even solve it. I also don't know if you transferring property during the middle of a code enforcement action will relieve you of the liability. I don't know that, and I'm not here to determine that. The only thing I have to determine today is two things. One, is there a violation? I am going to find a violation. But two, an important lesson to always do your due diligence with tenants. But I don't mean to laugh. It's just I've been there many times. Two is, how much time do you need to try and bring the property into compliance?
If the county would allow us 90 days to try to address the issue with the squatter and his family that live next door and legal counsel on our own, we think that would be sufficient time to hopefully get through this process. If during that time we do see any major roadblock or issue, if we may contact yourself or the county to continue this discussion, but I think that would be enough time to allow us proper counsel and to move forward with trying to get this resolved.
Would
I
it,
was wondering if we should continue it for 90 days and have them come back and see where we are.
that works too. I was gonna suggest 180 but that's
Okay.
either way, it's fine with me.
All right. Does the county recommend that I find the violation and continue it, or just continue it without making a finding?
I was gonna say just continue it.
Okay. Mr. Hampton, do you have any objection to that?
No, sir, I
All
don't.
right, then what I'll do is I'll continue this hearing for 150 days, and hopefully that will give some time to obtain a resolution.
Thank you very much, you guys.
And if you have any questions or concerns, you can contact Matt or myself.
Okay, and that ends the hearing. Thank you.
Thank you.
The second case today, Carolyn K. Borgerson, case number 2142504, Code Officer Matt Hampton, page 7 of your agenda. The expert will be Joanna Katu.
Morning again.
Good morning.
Matt Hampton, Citrus County Code Compliance Officer. This is case number 2142504. Special requirements for all accessory use structures. A violation of Citrus County Land Development Code 3102A. The address is 10603 West Oliver Street, Homosassa, Florida. Property owner is Carolyn K. Borgerson. A good service via posting of the property in the Lecanto Government Building. I would like to authenticate the documents and request that they be admitted into evidence. Exhibit A are photos I took during my initial inspection, June 8, 2021. Photos I took for my corrective action inspection, August 25th, 2021. And photos I took during my final inspection on September 14th, 2021. Exhibit B is a copy of the property appraisers showing it as a vacant lot, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit and picture of the posting completed on September 2nd, 2021.
Is anyone from the public here for this case, or wish to be heard? Let the record reflect that there is no response. What's been proposed as county exhibits A and B are evidence.
I conducted my initial inspection June 8, 2021, and observed the property to be in violation of the violation listed above. There was a boat, there was a tent, and other, a shed and other debris around the property. I've had no contact with the property owner. I conducted a corrective action inspection August 25th, 2021, and the tent was taken down and removed. However, the boat and other items remain. Notice of hearing was sent out August 25th, 2021, and as of my final inspection, September 14th, 2021, there's been no further change.
Does anyone else from the county wish to testify?
Joanna Coutu, Land Development. It is also a CLRMH vacant lot, no record of an application or a permit.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected by the action because based on the actions of the property owners. Once they were advised of the violation, this amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find it as a respondent's responsibility to contact the Code Compliance Division when the violation is abated in order to allow for reinspection.
Mr. Hampton, I notice in your affidavit that in paragraph 2 you state, I have attempted to serve a notice of hearing regarding an alleged code compliance violation upon Carolyn Borgerson. And then in paragraph 3 it says, due to the inability to serve the notice via certified mail or hand delivery, what was the attempt to serve her?
We sent out a notice of hearing via mail.
Okay.
Signed certified mail.
Okay, so
We
when it
would've
says
gotten-
or, it doesn't mean you tried both certified mail and hand delivery, it just means you did certified mail. This is a form.
Yes, sir.
Okay, all right. The property is found to be in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Ms. Borgerson. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. And for the record, I adopt the county's proposed findings of fact and law.
Thank you.
The next case, John S. Dwyer, case number 214-3689. Code Officers Amy Becker, page 11 of your agenda.
Mr. Dwyer? Mr. Dwyer? Can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do.
Thank you.
Morning.
Good morning. Amy Becker, Code Compliance Officer. This is case number 214-3689, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 4770 North Kenilworth Terrace, Hernando, Florida. The property owner is John S. Dwyer. I have good service via posting of the property as well as the Lecanto Government Complex. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on June 22nd, 2021. Photos taken on August 12th, photos taken on September 2nd, showing the posting of the property, and photos taken on my final inspection on September 14th, 2021. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit.
Sir, I'd like to ask you to take a look at what she's proposing as exhibits A and B, and let me know if you have any objection to them being evidence. And take your time.
No,
Okay. All right.
no, the pictures don't lie, no.
Okay, thank you.
No, that's,
Is there anyone in the public who is going to want to be heard on this case? Just curious.
Well, I'm his brother.
Okay, and you'll want to be heard later?
Yeah.
Okay, I just want to make sure that I give you a chance, and I know you're there, so.
Yeah, I'm just here to confirm that he's been working on it.
Okay.
He's accomplished a lot, and we've had a lot of dumpsters brought out. and-
I'll be sure to call you up before we're done, thank you. Then without objection, what's been proposed as county exhibits A and B are evidence.
On June 22nd, 2021, I conducted my initial inspection for accumulation of junk and debris and observed debris on the front porch and behind the second building, which is a clear violation of the ordinance listed above. As of my final inspection on September 14th, there has been major improvement at the property. However, there is still debris in front of the mobile home. I have had contact with John Dwyer, and he's aware of the violation.
Mr. Dwyer, just one moment, I'm just looking at all the photos
Yeah,
before I
yeah,
ask you
no,
about
no
it.
problem, no problem, take your time.
All right, Mr. Dwyer, what's going on? With the property, I mean, I've looked at the photos, what do you think? Is there?
I have gotten rid of a lot of stuff, but there's still a lot of stuff to go. Yeah, a considerable amount has gone, but definitely more needs to go. More needs to go. More needs to go. There doesn't seem to be any end to it. Yeah. Oh, no, you're not going to get any argument from me. I completely agree. that it's,
In the most recent photos, it appears that there are.
yeah, I pulled everything out. Well,
Well,
yeah,
hold on, hold on. So what I was gonna say is, it looks like there's a lot of garbage cans. It looks like you're trying to get rid of the debris. Is that right?
Well, yeah. Well, the rain has messed me up.
Ms. Becker, I have a question for you. On page 2 of 13, taken on June 22nd, 2021, I'm not it looks like there was like a yard sale or something. There's shirts hanging on the fence.
He
Oh, that
keeps-
was decoration. Yeah.
Mr. Dwyer collects things. He has two properties, one on the left too, that's been in violation numerous times. He collects things and then he exhibits them on his property, near his front lawn, near the mailbox.
Yeah.
Different-
No, yeah, go ahead. No.
Well, if you don't mind, let me let Ms. Becker finish. Yeah.
I
So he
apologize.
collects things and then he displays them in front of his properties. T-shirts, dolls, signage.
Okay. Now, exhibition is not against the code. It's if you leave it out there. I mean, can you tell me, is this a violation of the code? What's on page 2? Is this a part of the violation?
I don't have my glasses on.
Yeah.
No, I don't have yard sales. No, I don't have garage sales.
Either do I.
If it's a usable item, I just wanted you to be able to see the entire property. This is his other property,
Right.
so he has two, so this is the one on the right. And I'm concerned about the stuff in the front of the mobile home.
Well, I'm just asking, I'm looking at this page 2, and I'm wondering if this is a part of what you're alleging is the violation.
No,
Okay.
I just wanted to show you the
That's fine.
property so you can get a
Context.
clear idea.
Okay.
Yeah, that was for decoration.
Now,
Yeah.
if somebody did, just with that caveat being said though, if somebody did call it in and say he was having a garage sale, then I would have to revisit it, because you're only allowed 4 a year if he decided he was gonna sell those
No.
items. So it
Yeah.
could be in the,
You're only allowed 4 garage sales a year?
yes, you're only allowed 4 garage sales a year. 2 consecutive days, 4 times a year. So if somebody did call and say he was selling merchandise or something, that would be a different story.
All right, so actually, let me ask, Sir, you're the brother. Would you like to be heard on this? Can I ask you to come up, swear an oath, and then I'd like to take some testimony from you?
Mr. Dwyer, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Can you please state your name for the record?
Jeffrey Dwyer.
Thank you very much, sir.
Mr. Dwyer, what would you like to say about what's going on?
Well, he seems to have some issues, mental issues that we've been trying to get him to a doctor, get him evaluated. Hoarding, you're familiar with hoarding? It's an illness that I don't know how to go about getting him some type of help. We've been trying to get the Department of Families and Children involved, or Adult Protective Services. He needs some help. He's not taking care of his health, his teeth, and I live all the way over in North Marion County, so I haven't been able to really assist him with trying to get to a doctor or a dentist or eye doctor. He likes to go out and salvage things that people throw away. Where he lives, the community of Citrus Hills is right behind there, which is a pretty classy area. And they have, like Wednesday, I think it is, they're allowed to put out things, not garbage, but household garbage, but things, unwantables. And they box them up, and this has been going on. He goes and brings that stuff home to go sift through it and see what things. A lot of it is we take to the scrap metal. I've helped him out, all kinds of things, microwaves, cookware, silverware, and then we take the stuff to the scrap metal place.
Yeah, I mean, when I look at the photos, I actually don't feel like it's getting better.
Yes,
you
it's
know,
been an ongoing
there
thing.
may be efforts to improve it, but I don't think it's getting
I've
better.
helped him several times already get
Yeah.
straightened out with, she's familiar with me very well.
Well, Ms. Becker-
We've helped him several times getting straightened out, but then we go back to the same thing.
Well, again,
He don't break any laws, I know,
It's
as far as stealing or anything like that. or
criminal
alcohol or
laws, yeah.
drugs.
well, let me,
It's an illness of
Mr.
the
Dwyer,
mind.
let me just say a few things. So again, as I indicated at another case hearing, I'm not able to give legal advice to anyone here. My job is to determine whether there's a violation or not. But there are several ways to fix the situation that you're talking about. So, for example, powers of attorney, guardianships, if what you're alleging about your brother is true, okay? And so, whether it's that or whether it's finding help to clean out the property, it's got to be done. Ms. Becker, have you heard anything that you disagree with from the other side?
No.
Okay. How much time, Mr. Dwyer and Mr. Dwyer, do you think is necessary to bring this property into compliance?
We could probably, another month, we could get some more dumpsters out there and get a crew going at it, and I think we should be able to knock it out within a month.
Mr. Dwyer, John Dwyer, do you agree with that?
Yeah, 30 days.
Okay, all right. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day, along with administrative costs, to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the Special Master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I think this is a nice property. I'm looking forward to it being cleaned up. I am going to find that the property is in violation. Mr. Dwyer, you are granted 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. I'm adopting the county's proposed findings of fact and law. This fine will be recorded and will constitute a lien on your real or personal property. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and Mr. Dwyer, you shall be responsible to pay all costs required by county ordinance or regulation, which may also end up being filed as a lien of record. And that's it. 60 days. All right, thank you.
Well, appreciate it.
Yep.
Thank you.
Next case. Paulino Alfonso, case number 2146571, Code Officer J.C. Charlton, page 4 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name for the record.
My name is Paul Afonso.
Thank you.
Morning.
Good morning. J.C. Charlton, Citrus County Code Compliance Officer. Case number 214-6571, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address, 740 Southwest Bend Point, Lecanto, Florida. Property owner Paulino Alfonso. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request it to be admitted into evidence. Exhibit A, photos I took during my initial inspection on August 2nd and corrective action inspection on August 18th and my final inspection on September 14th of 2021. Exhibit B, the notice of violation, notice of hearing, and a copy of the signed certified mail return receipt.
Sir, I'd like to ask you to take a look at these and just let me know if you have any objection to them being evidence.
Okay. On the first one where the Lincoln is, that's been taken care of. That was done the same day he was there.
Okay, that's good. So that's a little different than what I'm asking. You're going to have a chance. I will give you a chance to say whatever you
Okay.
want about the photos. What I want you to do is just look through them and let me know if we can talk about them. I need to know that first, because if you have objections to their authenticity, then we may not be able to even talk about them. But if you don't have objections, then there'll be evidence and we can all talk about them.
Okay. Where's this at?
This is on the right side of the property.
I don't think I've ever been to that area of the property.
How big is the property?
7 acres.
Oh, okay. Well, that would
I've
explain
never been
it.
to that section. So.
Yeah.
Yeah, I see what this is. I've gotten, all of this stuff I've already picked up. Here's the one he was talking about where it's tin. It's not, it's plastic. It's a roof that got hit.
Well, let's talk about it, but first I need to know if I can admit these as evidence. So if you have objections to them, we'll have to deal with them. But if you don't have objections, then I'll admit them as evidence and then we can talk about them.
There's some here that I've already taken care of.
Okay.
This one I should object to because it's just a seat that I sit on at night.
Well, that's a challenge to the county's case. It's not an objection to the document. So I need to know if you have any objection to me actually looking at those.
No, I don't object to you.
Okay, all right, that's what I needed to know. Is there anyone else from the public who is going to want to be heard on this case? Okay. And so is it Mr. Alfonso or Mr. Paulino?
It could be both. I got
Well, what's your full name? What's your full name?
Paulino Manuel
Paulino.
Juan Alfonso.
Okay, thank you. So if I say Mr. Alfonso, that'll work, okay.
Yeah, I've been working on this since he showed up.
Okay. So without objections as to the authenticity of the photos, I'm admitting them as evidence, exhibits A and B, and we'll go and talk through them, okay?
Okay.
Thanks.
On August 2nd, 2021, I conducted my initial inspection and observed scattered trash and debris on the front of the property. While conducting a corrective action inspection, I was able to view the right side of the property from a neighboring property and observed scattered debris, scattered garbage that appeared that animals had went through. I have had contact with Mr. Alfonso, the property owner, and he has stated he will work towards removing the debris, and he has made progress towards the cleanup of the property. As of my final inspection on September 14th of 2021, there is some debris and items remaining in violation on the property.
All right, so I'd like to hear from you now, Mr. Alfonso. So he's basically agreeing with you that you have made efforts to improve.
I work overnights, I'm 64, and I only get 2 days a week to really work on it. And I have been working on it. The reason that debris was there in the first place was I got sick 2 years ago. I had a kid coming over to my property. I'd put the garbage at the front of the property. He'd pick up the garbage every 3 weeks. Well, 6 weeks, 7 weeks ago, he stopped coming. And that's why it's that. But I haven't stopped. When he was there the first time he came to the property, I already had some of the stuff already up there, and I was getting ready to take it to the dump. And I explained that to him, and he said, okay. And that's one of the pictures where the Lincoln is. I sold the Lincoln. The other car is up to code. It's
You
got a tag.
stole? Oh, you sold it.
No, I sold one car. and
Okay,
the
I
other
thought you
car-
said you stole it, and I was
No.
like, that's the first time
Right.
I've heard.
Yeah, I've got
Okay.
that one area that's there. I think I've got like 60–70% of it done, but I need a little more time to get the rest of it done.
Sure. How
There's
much?
one picture there that he showed me. I've never been to that part of the property.
Well, I mean, that's the thing. You know, under the code, you're responsible for the property,
Right,
whether
I
you've
mean,
been there or
I'll
not.
go look for it now. but
Well, how much time do you need?
if you can give me 60 days.
Okay.
Another question is that one thing where he said it's tin and it's a roof that collapsed in a thunderstorm, branch hit it, and I was saving money to fix it. That's why it looks like debris, but it's just a roof that collapsed.
Well, it is debris because it has collapsed. So under
Right.
the code, that's just the way it works.
So
But-
what I'll do, I'll just tear it down and get rid of it.
Yeah.
If I can get another 60 days, I'll get it all done for you.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests Special Master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given to the severity of the violation and respondent's actions relative to this violation. We would also ask the Special Master additionally find that it's respondent's responsibility to contact the Code Compliance Division when this violation has been abated to allow for reinspection.
I adopt the county's proposed findings of fact and law. Mr. Alfonso, you will get your 60 days. You're granted 60 days from today to abate the violation. However, if the violation is not brought into compliance as ordered, a penalty of $50 per
Right.
day will be imposed. This fine will be recorded and will constitute a lien on your real or personal property if it comes to that. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of their recording. And you will be responsible to pay all costs required by county ordinance or regulation, which may also end up being filed as a lien of record.
You
That's
got
it. Thank you.
Thank you.
I understand. Thank you.
All right, the next case today, Mary Lorraine Hanson, case number 213-3108, Code Officer J.C. Charlton, page 13 of your agenda.
Bless you.
Good morning, Ms. Hanson. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name for the record?
Mary Lorraine Hanson.
Thank you.
Can I take
Well,
this
we
off?
need you to. Did you affirm that you would swear
Yes.
and affirm that, I don't know the oath, but
Yes, my daughter.
I didn't hear you say anything.
Oh, yeah, sorry.
Okay. And what's your name for the record?
Jocelyn Palmentary.
Great.
I'm sorry?
Jocelyn Palmentary.
Thank you.
J.C. Charlton, Citrus County Code Compliance Officer, case number 213-3108, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 4025 North Bloom Point, Crystal River, Florida. Property owner Mary Lorraine Hanson. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during my initial inspection on February 9th, corrective action inspection on August 12th, and a final inspection on September 14th, all of 2021. Exhibit B, copies of the notice of violation, notice of hearing, and a copy of the signed certified mail return receipt.
Ma'am, I'd like it if you could take a moment and go through the documents you're about to be shown. Let me know if you have any objection to them being evidence in this hearing.
I do, but let me look at this real quick and then. That's gone.
Yeah, you have to, this is just so he can look at the stuff.
Right. That's gone.
So I understand that you'll be making commentary that the photos do not accurately depict the property as it stands today, correct?
Correct.
But what I'm actually asking is if you have objections to these documents being used as evidence to reflect what they showed on the dates on the pictures, right? So,
Yes, not on the dates of the pictures. Mr. Charlton came out and all this is gone, so,
We'll get that out later. This is just so he can look at the.
that's right.
okay. So, yes, Mr. Charlton showed up. The day that he showed up was the day I had just got my permits to set up a new home. I bought an old schoolhouse modular.
Well, ma'am, no, I'll definitely give you a chance to explain your side. This is just a preliminary issue. I'm not allowed to look at these photos unless and until we can ascertain whether or not it's good evidence, all right? So you've been shown photos from February 9th, August 12th, and September. Okay, so you've been shown photos from February 9th, August 12th, and September 14th. Do you have any reason to believe that these photos are not authentic?
Today's the fourth, no, today's what?
Today's the 15th, I think?
Okay.
Yeah.
Yeah, that's not like that now either. Isn't that what we just tore down?
No,
I'm just trying to figure out what this,
that's the back of the property.
yeah, but I don't have this canopy, that's what I'm asking, unless it's on my motorhome.
No, that's back on where the RV used to be.
That's the back side of it.
Yeah.
Okay.
Ms. Hanson, here's what I want to know. Do you have any reason to not believe that the photos taken are authentic on the dates that they show?
No, sir.
Okay. And then on Exhibit B, there's a notice of violation, a notice of hearing, and a signed, I guess, certified mail affidavit. Do you have any reason that I shouldn't consider those as evidence today?
No.
Okay, and take your time to look through the documents. I want to give you a chance to also comment on them and say everything you need to
Yes,
say,
please.
but I need to have them as evidence before I can do that.
Okay.
So I haven't heard any substantive objection to these documents being evidence. Is there anyone else from the public besides Ms. Palminteri?
Yes.
Palminteri, who wishes to be heard on the case today? All right, let the record reflect that there is no response, so.
Is this next door or is this the property?
I have 2 acres.
Oh, okay. Is that next door?
No, this is the,
Okay.
this is the whole property there.
It's a big piece of property.
Yes.
Thank you. So without substantive objection, these exhibits A and B are evidence, and I'm going to give Ms. Hanson a chance to talk about all of them when it's her turn. Okay.
I conducted my initial inspection on February 9th, 2021, along with environmental health. I observed a large amount of discarded items, dismantled automobiles, automobile parts, scrap metal, debris on the front of the property. I had contact with the property owner at the property, and she stated she would need some time to remove the debris because it was a large amount. I gave her additional time to remove the debris. I received another complaint on the property, and it took some time because I only can access the front of the property, and it sits back off the road. I can't see it from the road. And if no one's there, I can't get in without trespassing on the property. There's
Are
several
you
of those
saying there's
trespass
a,
I'm at a dead-end street.
Right.
The road literally dead ends at my property.
I see, okay.
So additional time was even given due to that fact. I have to access it from a county easement that constantly is flooded throughout the year. I was able to get access to that easement during my corrective action inspection on August 12th, and that's when I seen a significant amount of debris on the back of the property as well. The front of the property, you can see it looks like a privacy fence was put up in an attempt to shield some of the items from view. But
Well,
as of,
I mean, first of all, let me go in order of my questions, and then I'll get to Ms. Hanson. Did you say environmental health in the beginning?
yes,
What was that all about?
there was a complaint with them also, something with the sewage,
Okay,
and they went out along. We happened to get there at the same time, and that's how I was able to get access with the initial inspection.
okay, but that didn't turn into a code violation of any kind, the environmental health aspect of it?
No, we already had a complaint for the junk case.
Okay, all right. What I'm getting at is there's no issue as to public safety or
Right.
before me today.
No issue, yes, sir.
It looks to me like there is a big difference between February and today. Would you agree with that? No? Let me show you, so I'm looking at page, I guess 4 of 11, and there's a huge amount of tires and debris with the cars and stuff. Is that still there?
Correct. I cannot see that.
Oh, you
so-
can't see it?
No.
Okay.
So, but I mean, from the corrective action inspection and the inspection I conducted yesterday, there is a significant amount on the back, and just certain angles, the photos that might not depict, but seeing it from, I can testify to the eye, it is a significant amount of debris back there on the back of the property.
Is this the only case being brought on this property today?
No, I have 3 other cases on the property that.
Okay. I assume that they'll,
That for not
okay, but I
today's
assume
hearing.
that they include something about the vehicles.
Correct, yes,
Okay.
sir.
All right, Ms. Hanson, so you've heard what the county's case is here. Tell me about what's going on the property.
Okay, well, let me start off with when I bought the property, everything was on it. When I come in here to I bought a new home, or I used home, a modular, an old schoolhouse.
When did you buy it?
I got that in December of 20.
Okay.
The day I got my permits to, in February, and I'm sorry, I'm trying not to get emotional. The day my permits went through, in February, he showed up. And environmental health showed up right behind him. Well, we had neighbors that moved there, that bought a place. Now, they have already sold their home and moved on, that threatened me that he was going to do all this. Now, I'm a single grandmother, disabled, raising 4 grandchildren. I told JC this when he came out. I have 9 scrap loads that I took out of there.
Okay.
2 dump runs. I still got a trailer full to go. In the midst of this, I'm trying to tear down my home so that a new one could be set up for me and my grandkids who are having to stay with somebody because Mr. Charlton has been on me so bad that I had to stop working on my home and try to get everything down on the property.
Let me ask you about
now,
that,
the
Ms.
first
Hanson.
letter.
Let me ask you about that, though, but I don't want to forget. So you talked about getting a permit in February. What was the permit for? Is that for the new home?
Yes.
Okay, so you applied for a permit to construct a new home in February, and then the code violation issues
Same day.
started. Okay.
Same day. And I told him that. I said, I just come in and I looked at environmental health. I said, I just left your office. I said, I have an appointment with you guys tomorrow. That was checking my drain field, make sure things are good for their new home. And little JC looked around and he's like, you know, you need to do this. Everything he told me to do, I did it on my letter. Then he informed me that there was violations on that property from way back before I ever got it. Well, when we did the title search, me and L. Wayne Petshaw, the man I bought it from, when we did the title search, there was nothing against the property. We were right there at the state of Florida doing it all. Nothing when I got the title, because I had to go through a lot of stuff to get the title to the property, to the home, and the deed. Yes, it looked like a junkyard. Oh, it was bad. It was a path.
When you bought it,
But that's the way I bought it.
okay.
Since then, I have removed just about everything. I have a wrecker, a 69 truck, old trucks, and an Apache. They're project toys. The one was a wrecker. It got destroyed. Somebody decided to come in and destroy it. All the debris on that trailer, that's all gone. All the debris that was laying around, that's all gone. All the tires, they're all gone. I put privacy fence up. Nice privacy fence to when you come to my driveway, you can't see anything. It's behind that. I hadn't finished it yet because in the meantime, I'm really upset with this guy. In the meantime,
Well,
my new home,
I can tell, but
my new home is sitting there, and I have to redo half of it because he's been on me so bad that I've had to stop working on my home, my new home, to put my 4 grandkids into that I have custody of.
well, Ms. Hanson, it sounds like you're doing something good on the property.
I'm
But
trying to, but I got half of my
but-
home's destroyed now that I have to go in and rebuild it because he keeps on me.
And I gave all the time that I could
had to
give.
get extension.
Ms.
I mean-
Hanson, here's what else. Let me just. It's
I
rare.
don't-
It's rare. You're entitled to that, but it's rare that a case starts in February and only comes to me 7 months later. So it sounds like there has been a substantial amount of time that Mr. Charlton has provided. It's rare.
In this
It's
time,
rare.
and in this time, I only had till August to get my modular set up.
Right.
You only had 6 months. I had to call up here and get an extension
Yeah.
of a year because it doesn't set us back that far.
I won't
Because
speak for the county, but I've never found them to punish people for trying to do the right thing and bring the property into compliance. But
now
let me ask
he's
you this.
telling me that on the right, the last phone call I got from him, and I have it on voicemail, he's telling me that from the right side, the back easement on the right side is a problem. First of all,
The back
that's
easement?
private property.
The back easement?
Yes, that's private property back there, state property. It's private property.
It's a county easement.
So when they're coming over, where they're coming over at, they're not supposed to be coming over at. They come through my yard, that's trespassing.
Well, actually, so let me
But-
ask you this, Mr. Charlton. Have you received permission to go and inspect on the property from Ms. Hanson?
Nope.
No, I don't go on her property.
No, I
That's-
know. I'm
No.
not accusing you of
Yeah.
doing something wrong. What I'm curious about is her cooperation.
I have
Just
corroborated.
during the initial inspection.
Okay, so I'm hearing accusations of potential trespass and things like that, and the county code indicates that cooperation with code enforcement is a factor. It doesn't sound like you're getting it.
No.
Okay. Ms.
And I
Hanson, why
have
are
been
you
complying.
not?
I
Ms.
have
Hanson,
been complying
you're
the whole
entitled.
time.
It's your property, so but I want to let you know that in the code, it makes a factor for a special master to consider whether or not the property owner has been working with the county. Now, you've no doubt, based on the evidence I have, you've made improvements. I'm not
if-
denying that, okay?
If I was trying to get pictures of today, and
Right.
you check and see if they came yet, just so that you could see what it looks like right
Well,
now
unless
as
you
of
can
this
print
morning.
them out, I can't use them because I would need to take your phone as evidence to stay.
Got you.
Right?
got you.
So, but here's what I'm getting at. I also, it seems undisputed.
Can I actually come up there and address them pictures and show you? And
Well,
then then-
what I'll do is I will give them back to you. Mr. Tron, would you mind?
Oh.
I'm sorry. I'm familiar with the photos, so if you talk about them from where you're at, I'll be able to follow along. Just show them to us as you're discussing them.
Okay,
We did
but-
some stuff yesterday too, that's probably why. He probably came before we got there.
I'm sure,
Cause
but
after I got off of work at 5.
but it does sound uncontested that there's still some stuff that needs to be fixed.
Well, he told me when he came out, he said, you do everything I ask you to do. And I did. I did everything. I made sure all the I's were dotted, all the T's were crossed. And I called in his office. I left a message for him to come out to do his interview or whatever. The
Inspection?
And never seen him, and
Couldn't
then I
access
get
the
a phone
property.
call, my uncle
Ma'am, he
said,
can't do that inspection unless he receives
And
your
no-
permission
no
to
one
go
was-
onto the
my
property.
uncle
No one was there when I went there.
Okay, no one was there.
And my uncle has aphasia, which Mr.
What-
Charlton knows, I
what-
told him that from the
Miss Hanson,
get-go.
Miss Hanson, hold on. What type of aphasia?
He lost the ability to read and write
Okay.
and talk.
Okay. Now,
But I was
let's
gonna
go
back
through the
to-
photos. We want to
Okay.
do this in an orderly way.
That's what I was trying to do a
Okay.
second. Okay, all this debris on the photo one, that's all gone. And it wasn't on my property to begin with, it was on the property next door. They bought it, this is where everything started, they had their property surveyed, each corner.
I want to stop you there. So you're saying the debris on page 1 of Exhibit A is gone. That
That's
photo
gone.
was taken in February.
That's gone.
So hold on, we're not moving on yet. Mr. Charlton, do you agree or disagree with what she just represented about page 1?
Oh, that's gone.
Actually,
It's not on her property or?
two questions. Does the photo show it on her property, and is it gone today?
Yes, it shows it on her property.
And is it gone today?
If you look right here, do you see the orange? That's the property line. That is on.
Hold on, Miss
Alan.
Hanson.
I'm just
No,
trying to explain
no.
to him
I'm not
it's on
interested.
Alan
Honestly,
and
I'm not
his
interested.
property.
I'm no. I just want my questions answered, if you will.
That's gone.
Okay, that's all I
That's
wanted to
fine.
know. So now let's go on to page 2.
Okay, so the next one is the Ford truck, which belongs to her.
Okay.
It's gone.
No, let's show the photo a little bit longer to me so I can see it. That's not at issue at this hearing, so that's okay. Let's go to page 3.
That's gone. Well, it had been. You moved the pictures out of order, I think.
No, this is current. It has numbers on it.
All right, this is, well, of course, that's her car parked right there. My granddaughter's toy, her mud truck. This is my new modular that I bought. That this side is totally ruined now because it hasn't been put together yet. Okay.
Hold on. We're now on page 3. Mr. Charlton, is there anything on page 3 that indicates a violation? This is again taken back in February.
Oh, yes.
Okay, and what's shown on page 3 that's a violation?
Oh, on 3, I was looking at this one, I'm sorry. No, not on page 3, that was just
Okay.
a general overview.
Got it. I agree with you. So let's go on to page 4. Ms. Hanson, you first.
Okay, page 4. Sorry, I have bad hands. All this is gone.
And you're talking about the junk and the
All
debris,
junk
the
and
tires.
It's gone. I already took it to
Okay.
the scrapyard or the dump. With
Okay,
either one.
now I want to hear from Mr. Charlton. So, Mr. Charlton, this is what you testified you can't
I
see
cannot verify that.
due to the privacy fence.
Correct, yes,
But
sir.
I hadn't finished on this picture yet. Now, he started out, now when I come here to get my permits, started out, they pulled up an aerial view. And the lady asked me, she says, well, what is this? Well, this is an old semi-trailer, unroadworthy, we can't move it, I tried. It was on the other side of the house, where we're putting the new house at. So she said, that's gonna be a problem. I said, okay, so my friend that lives up the street come down and he moved it. So we moved that and the old camper, cause it does run, but I'm trying to give it away.
Okay.
We had those two moved,
Okay.
so that it would, so we can get our new house put in.
Right.
The mud buggy, I mean, I
Well,
live on a mud
no.
hole.
I'm gonna stop you. I don't think that stuff is relevant for this case. It's probably relevant for some of your other pending cases. So let's move on to page 5.
Okay, page 5, all the debris that's laying here, it's all gone.
It's almost the same picture.
It's almost the same
Okay.
picture,
I'm going one by one. Mr. Charlton, again, is this stuff you can't verify due to the privacy fence?
Correct.
Okay.
other than the motorhome, and I do have a
Let's
thing
go
for
on
it.
to page 6.
Page 6 is where we were tearing down the addition. I had permits. I was told as long as I have permits, I can't be messed with. Why I'm in the permit process, where I'm in the new house set up. So we had to tear down the back addition on the mobile. This is my granddaughter's toys.
It's not that, it's this right here he's talking about.
Scrap metal and stuff
This
and debris
is
back there.
this just come down within the last month. I had 2 additions I had to tear off. the old place. It was an old 76 trailer. So it had two additions, the front and the back that had to be torn down. This is the back part. So I'm disabled, so I'm doing
Hold on,
it
all
one
right.
time.
So, Ms. Hanson, you've said what you need about, I think we're on page 6.
I
Mr.
have-
Charlton.
For regards to the permits, she doesn't have a demo permit, it's just a replacement.
Oh, I get it. I'm not even
So it's-
addressing that. So what I want to know about page 6, Mr. Charlton, is what are the violations shown on page 6?
Scrap metal and debris.
And what's the date on that one?
This is August 12th.
Do you know if that's still there?
Yes.
Okay. Now, Ms. Hanson, basically what you're saying is you think that you should be allowed to have that there because you do have a permit. Scrap metal.
I'm tearing, it's coming down off the old house.
It's a yes or a no. I mean, I don't.
Yes.
Okay.
Yes,
Okay.
because I had to tear the additions down.
Okay.
Which is what the mobile home place told me to do. I had to disconnect the
Okay.
additions so they could
All
take
right.
it out. And I do have a thing with the
Let's go on to
motor
page.
home place.
Let's go on to page 7.
Okay, page 7 is the Dodge truck, which is legal. There's a tag on it for 22.
Well, let me skip it. Mr. Charlton, is there anything in this page that you're claiming is a violation? Because I don't
Yeah.
need you to address it if Mr. Charlton's not
That's
saying.
gone.
They're not looking at the vehicles, they're looking at the
Still on the
metal.
ground here, there's a trailer with debris on it, auto parts, I mean,
And so,
With the tag, I gotta take it to the dump. I'm one person.
okay.
I'm raising 4 grandkids, 16 to 9.
All right, I've heard enough, basically. So here's the deal, Miss. Well, actually, I need to let you say whatever you want to say.
Okay,
That's
the
that's
Jeep-
the fact.
This Jeep, we're pulling the motor out of for the Dodge. The Dodge is legal. Hopefully I can have this done within the next couple of weeks. I am trying, because I'm trying to get my new home set up.
Miss Hanson, I might be able to save you some time here. So here's the situation. There's a lot of different things going on with this property. I'm in no doubt that you're making an effort. I'm also not in any doubt that this is an important property for your family.
Yeah.
That's all. You've done the right thing in getting a permit to make this livable. That's not really a dispute here. There's only one issue for me, which is this: is it in violation of section 20-31A? And this regards, discarded household garbage, trash and debris, auto parts, miscellaneous junk and debris. And so you've testified, and actually I agree that there's been significant improvement on the property, okay? But there's still 2 problems. One is that it's frankly undisputed that there's still some debris there. And you're telling me you can get it done, but you're only one person, all right? So what that means is I need to listen to you about how much time you need to fix it. But it does sound like there's an issue, right? So Mr. Charlton is having a hand tied behind his back because what he's saying is he doesn't think he's getting permission to come on there to do a final inspection. Now, what I'm going to do, again, and I've already seen enough based on your testimony to find that there is a continuing violation. But what I'm going to do is I want to give you enough time.
Can I sit
Of course you can, ma'am. Yeah, please. In fact, take as much time as you need to sit. Can you hear me okay if you sit? All right. I need to know how much time you would need to fix this junk problem. I'm not talking about the cars because that's not in front of me today. I'm not talking about anything else. I'm just saying, how much time do you need to get rid of the junk? And what Mr. Charlton is saying is the debris and the scrap metal, because I am going to find that that's a violation. But I want to know how much time you need.
At least till the end of the year. I mean, 4
Okay.
months, 5 months.
So today is,
I mean, I've got, like I said, I'm trying to get my modular set up,
okay.
and every time I'm trying to do everything to make him happy. And he told me the only reason you're in trouble is because a neighbor called in, which I got threatened. I know that. They've already moved.
Right.
I've done everything. I've been trying to do everything. A lot of this debris gone. He has my phone number. All he's got to do is call me, and I'll meet him at the property, and I'll walk him through the property.
Well,
I
here's
have no problem with that.
You also have his number, and so
And
if
I have called him, and
Okay.
I have left him messages.
but when you do make improvements, you got to call him and let him know.
I did.
Okay,
I
okay.
did.
All right.
And it's the semi-trailer, he keeps on me about that, saying it's commercial and residential.
Well, I'm just here for the junk. You know,
Well, that is considered junk.
well, not,
It's all
not for,
rusted out, it's not.
I don't, well,
really-
maybe it
I
is.
mean,
Is the
we
trailer a
moved
part
it-
of this one?
Well, I mean, it's in bad shape. I mean, it's,
One side to the other, so we were trying to make it a shed, drop it down, make it a shed, you know.
but I do
slash
have I do have another
but I
case for it, and
also have it
that's
for sale.
Okay.
another case.
You're telling, so I just want to make sure I understand what you're saying correctly, and that I give you a chance to be heard. That's the requirement. It's called due process, okay?
Right.
Not everyone likes it, but that's, that's the reality. So, you've said that you need until the end of the year to fix this problem, correct?
Correct.
Okay. Is there anything else that you want to tell me about the junk and debris issue?
Yes.
Okay.
The semi-trailer, he keeps on me about it, it's not roadworthy. It fell apart, moving it from one side of the yard to the other. It fell apart. So, when we moved it out on the other side, it's moved again, because I was trying to comply, to get it moved, so it's a privacy fence, to use it as a privacy fence. However, we were on COVID, we just came off of COVID, we were down since August 26th, 23rd. My granddaughter just went back to school Monday. 4 kids home, quarantined at my dad's house. I mean, I had no control over that.
Right.
We were sick. But I did have a friend go in and move the commercial trailer, which is not, it was there when I came. And where he doesn't have it exactly on my property line yet, but we're in the process of having the modular moved. So, I mean, things are in the way. And once the modular gets moved over and set up, then I have room to move things. But I have gotten rid of everything else there. I've got 2 junk cars, I think, and they both got for sale signs on. If you can access my property from the backside, and that's what he told me, it was on the phone, that everybody could see it from the backside when they go to the mud hole. First of all, that's private property, you're not supposed to be back there anyway. Second of all, if you're already breaking the law coming back there, whoever, and
Well,
I'm not saying him, I'm saying all
Ms.
the
Hanson,
other
what I've
people.
heard, and it's not really rebutted by you, is that the county has an easement by which it can.
Yes.
Do you know what that is, a county easement?
Yes, I do, but
Okay.
it's for the county, it's not for everybody else, and he's.
Well, but you just said he's breaking the law, and
Well,
I
he-
want to be clear that that wouldn't be true if there's a county easement there, right?
Well, I guess it's a county easement, there's.
You don't know.
Exactly.
All right, well, he's saying there is one. So, based on the evidence, it sounds as though there's a county easement, and I don't think your accusation that he's breaking the law is well taken. It doesn't make me find your testimony more credible, okay? I think you're
I feel like I've been violated.
I know,
by
and I
people
get
back
that.
there.
I get that, but it's not an excuse to accuse someone of breaking the law when you have no evidence of it, all right? And vice versa. The county's not allowed to accuse you without evidence. The problem is, I do have evidence. So I don't think it's intentional, and I think you're trying to improve it.
This property I've done a 180 on this property.
Okay.
Since I first accumulated it. If you pull up aerial views, you would see.
So-
I mean, it was like, it looked like a junkyard. I
So
was told it was a junkyard at one time.
here, I'm looking at.
And these other cases, I have no knowledge of these other cases. I've never heard anything about it until he said something about it.
Well, oftentimes people are unaware of violations until the county informs them about it. In the opening statement, I think I mentioned that if I do find that there's a violation, it's the owner's responsibility to contact the county when it's been fixed. And
Right.
so that's going to be a part of my finding in this case, that if you keep, given the time that I'm going to give you, once it is fixed, I've got to call Mr. Charlton and let him know. And he needs the ability to go and verify that it's been done. Does that make sense? Okay.
I have no problem with that.
This is, so, what I am going to do is I am going to go ahead and find that the property is in violation. However, I am going to grant you 90 days, which will take to the middle of December. Is that right? Is that?
Was it?
Okay, you're granted 90 days from today to abate the violation. If the violation is not brought into compliance, well, what's the county's recommendation?
I don't say what violation, on what part,
Uh,
cause I'm trying to set a home up too. I mean, we're living at my father's house right
Hold
now.
on, ma'am. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests Special Master assess a fine of $150 per day, along with the administrative costs began after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondent's actions relative to this violation. We would also ask the Special Master additionally find that it is respondent's responsibility to contact Code Compliance Division when this violation has been abated to allow for reinspection.
Ms. Hanson, what we're talking about is the junk and debris. And so I'm not talking about anything else, but this junk and debris has to be fixed within 90
Some
days.
things that you consider junk, we consider gold.
Like what?
Like, I have a bunch of jet skis there.
That's not, it is,
I have boats there, but I know this is, I know
Mr.
this
Charlton,
is
are the
where
boats
it's
and
going,
jet skis a part of the junk and debris here?
Because he told me he's not done with me, and
There's some boats from the distance. I mean,
Well, here's
that look,
why.
but
Well,
I can't.
we have to be clear about this because she has to know what she needs to do to bring the property into compliance.
Right. I have other cases on the property for unlicensed vehicles and things
So the
like
boats
that.
would fall under that
wait a
one.
minute, all my vehicles on my property are licensed, tagged, and insured, other
Ms.
than.
Hanson, for this case, we're not here on the unlicensed. I can't be more clear about that. I don't want to hear about that anymore. And so we're here about the junk and debris, which, to be clear, it's not the boats. It's not any unlicensed vehicle. It's the scrap metal, it's the auto parts, it's the other stuff that's been strewn
Alright,
across.
sir, can I explain to you that we are tearing down? We have to tear down the front porch still, so there's more aluminum and stuff. And as I'm doing it, I'm trying to put it in my shed so that I can so it can
So,
be
Mr. Charlton,
reused.
let me ask you about her point. So she's saying she's tearing down things, so necessarily she has to keep debris on the yard. Is that
The front
accurate?
and the back are both being
I
torn
mean,
down.
she has a permit for a replacement mobile, and it says in there, existing mobile home will be removed intact. No
Really?
demolition permit required. So, I mean,
Can I see that?
yes.
I mean, is that evident? Can you show it to the other side? I'd like to have that as evidence. Can you please review that? Is this a copy of the permit that you have?
I have permit, yes, I came through here to get everything. We had replacement 1999 modular home, 28 by 60. An existing mobile will be removed intact, no demolition permit required, because they told me I had to tear the rooms down and they would do the rest.
What I'm asking is this a copy of your permit? And do you have any objection to it being evidence in this case?
No,
Okay. I'd like to see
I
it.
don't. I would just like to be able to get my grandchildren into their own,
Yeah.
into their own home.
Right.
He's trying to give you time.
Okay. Without objection, this is County Exhibit C.
Yeah, but 3 months ain't nothing. I have till September to get the other house set up. I mean, it's already ruined. I already gotta rebuild half of it. Because of being stuck behind because of this.
I believe she said that she's got to take the addition porches off or rooms for the company to come and remove the mobile home.
I see.
Thank you, and I'm disabled and I'm trying to do it all. Cause I don't have the money to pay people to do it.
How much time are you going to need to, well, let me put it this way.
I have until September of next year for the modular to be set up.
Okay.
And I need to get that modular set up yesterday. I mean, like I said, half of it, I have to redo the whole ceilings now because it should have already been put together. And I informed Mr. Charlton of this the day he came out. I informed him I just got my permits today. I was excited. So I just got my permits today. I'm a single grandmother. I bought this home, an old schoolhouse, and I'm turning it into a home for my 4 grandchildren that I'm raising because the state put them with me.
Ms. Hanson, you have told me that, and I'm not deaf. You know, I appreciate, I'm listening to you.
So I'm trying.
But
I've been trying
you're
to do
repeating,
everything.
you are repeating yourself, and so I just wanted, there's a lot of other people here for their hearings as well, so, you know, you need an opportunity to be heard, but I have heard what you've said. And the issue here is even if you're taking down some of the other things that you need to get this, the original structure there moved intact or removed from the property, you're not allowed to just leave it, as debris on your property.
Hey, I have a question for you on that.
Okay.
Now, they're taking the 76 and they're pulling it over to the side. I'm trying to make you aware of it too, Mr. Dalton.
Yes, ma'am.
And they're pulling it over to the side to give me time to get my belonging and stuff out of that to put into the new home.
Okay.
So, they said that they can leave it as long as I need, but I need to know that I'm not gonna get in trouble for the old 76 sitting there once they move it out of the spot and block the other one. So
I'm
they
not
can put
aware of
stuff
that
up.
being at issue in this case, so it's not something that we're going to deal with in this case. I do encourage you to talk to Mr. Charlton or whoever's managing your case for the county on that to get an answer to that. If that case does ever come before me, we'll talk about it. I hope it doesn't, but we're only here on the junk and debris. You're gonna have 90 days, okay, to fix it. I am adopting the county's proposed findings of fact, but I'm gonna tell you, Ms. Hanson, that if the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed, okay? That's after 90 days to fix the junk and debris on the property. This fine will be recorded and will constitute a lien on your real or personal property if it comes to that. And the county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And Ms. Hanson, you'd be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. But Ms. Pontieri, I wanted to hear from you too. I mean, do you have anything else that you want to offer?
Are you able to come out and meet with us to walk through the property and just let us know what we need to?
Absolutely.
Okay.
Absolutely. But
Okay.
I go through the whole property. So, I mean, that way I won't have to go through the back to the easement.
Right, I understand,
Well, right
yeah.
now it's a mud hole.
Yeah, all the rain. But I mean, yes, the 90 days is great. That'll help out a lot. And as long as we can meet with him and
Absolutely.
like I'll have my husband there as well. And
I encourage that, okay?
so that way we've
I
tried.
think you will solve it, okay?
I guess one thing we did leave out is it is a mud hole right now. I mean,
Yeah,
I
it's a lot of
can't-
rain.
You mean it's wet?
Yeah.
Okay.
Wet, yeah.
Yeah, it's very hard.
Yeah, I get it. This is the time of year.
So I've had a hard time getting things with
Look,
the rain and all
you've
that.
got 90 days now, all right? This rain and stuff does not usually extend into
Hopefully it'll be gone
November and December, but, we'll knock on whatever material we've got.
Right.
That's the way it is now. If for some reason you and the county come to some agreement on an extension or something, that's between y'all, but that's my ruling for today, okay? I appreciate your patience and your time, everyone's.
Thank you.
And that concludes this hearing. Okay, thank you.
The next case, Gene Lubowicki, case number 2143749, Code Officers Matt Hampton, page 14 of your agenda.
I'll put that back away in here.
You want to come up for the case?
You were that riveted by the prior case.
Would you like a chair up here?
Sir, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Can you please state your name for the record?
John Burton Wyatt.
Thank you, sir.
Morning again.
Morning.
Matt Hampton, Citrus County Code Compliance Officer. It's case number 2143749. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of Citrus County Code of Ordinances. The address is 7419 West Chassahowitzka Street, Homosassa, Florida. Property owner is Gene Lubowicki. Goods servers via signed certified mail return receipt. I would like to authenticate the documents and request that they be admitted into evidence. Exhibit A is photos I took during my initial inspection on July 26, 2021. Photos I took for the corrective action inspection on August 17, 2021. And photos I took during my final inspection on September 14, 2021. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Sir, can I ask you to take a look at these documents, take your time, and let me know if you have any objection to them being used as exhibits, or I'm sorry, evidence in this case?
It's fine.
Okay. Is there anyone from the public who is going to want to be heard on this case? All right, let the record reflect there's no response. And without objection, what's been proposed as exhibits A and B are evidence for the county.
I conducted my initial inspection on July 27, 2021, and I observed the property to be in violation of junk. There was loose junk, trash, auto parts, scrap metal spread around the front of the property. I did have contact with Mr. Wyatt as of yesterday, but before that I had contact with nobody. I conducted a corrective action inspection on August 17, 2021. There was some progress, but still a bunch of scrap metal and junk everywhere. Notice the hearing was issued on August 17, 2021, and as of my final inspection, September 14, 2021, there has been a lot more progress towards cleanup. A lot of the trash and junk has been removed. However, there were still 2 trailer loads full on the right-hand side of the property, and I will say that during our conversation that I had with Mr. Wyatt yesterday, he had claimed that after I had left and taken my inspection that he had removed at least one of those trailers, and I told him to make sure he comes today to provide that evidence.
Okay. And, I mean, it looks to me like there's been a huge amount of improvement.
Yes, sir.
But there is still a violation,
Yes.
probably. And your name is Mr. Wyatt?
Yes.
You're not the owner?
No.
Are you a tenant?
I'm a tenant and I'm responsible for the property.
I see, okay. Well, I mean, it sounds like you've made a real effort. Do you have anything you want to say about it?
Well, the one trailer was loaded with trash. It's gone, and it's actually anything that was left in the yard is back in the trailer, and it's going today. So
Okay.
to leave here, it'd be going out.
Okay. Well, then how much time do you need to, just in an abundance of caution, I mean, is 30 days enough time for you to?
Plenty.
It is? Okay.
Yes.
Well, I don't need to belabor this one. Mr. Wyatt, the property is going to be found in violation. Ultimately, the property owner is actually going to be responsible if the violation continues, but the property owner is granted 30 days from today to abate the violation. If the violation is, I'm sorry, what is the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master find that it is the respondent's responsibility to contact the Code Compliance Division when violation is abated in order to allow for reinspection.
Okay. I do adopt the county's proposed findings of fact and law. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the property owner. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Good luck.
Thank you.
Yep.
Just give me a call.
I will.
The next case, Jonathan Tyler and Anthony J. Palumbo, case number 2144170. Code Officers Amy Becker, page 16 of your agenda.
Is Mr. Pearson only here today to cause trouble,
Yeah,
or
pretty
is
much.
he gonna?
Well, what am I doing?
Mr. Palumbo, do you swear to tell the truth, the whole truth, and nothing but the truth? So help
I
you
do.
God? And your name for the record, please.
My name is Jonathan Tyler Palumbo. Anthony is my father.
Gotcha.
Thank
Thanks.
Amy Becker, Code Compliance Officer. This is case number 2144170, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 17 East Murray Street, Beverly Hills, Florida. The property owner is Jonathan Tyler Palumbo and Anthony J. Palumbo. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on June 25th, 2021, photos taken on July 9th at my corrective action inspection, and photos taken on my final inspection September 14th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt for July 17th, 2021.
Mr. Palumbo, if you could just take a look at these. I know you've been here, as I've said it, for several other people.
Yes, sir.
Just let me know if you do have any objections to these documents.
I have no objection.
Okay. Is there anyone from the public who is going to want to be heard on this case? Okay, let the record reflect that there's no response. Oh.
Sorry, these are fill out.
Without objection, what's been proposed as exhibits A and B are evidence.
On June 25th, 2021, I conducted my initial inspection for accumulation of junk and debris and observed a sofa, refrigerator, trash, nightstand, and chair in the front yard, and which is a clear violation of the ordinance listed above. As of my final inspection on September 14th, the couch sofa is gone, so the nightstand and the chair remain. I have had contact with the owner.
Is this the only case on the property?
Yes.
Okay. So what's going on, Mr. Palumbo?
I was doing some cleaning out inside my house, and I don't have any way of transporting anything larger that can fit into a 2007 Scion TC. So anything larger, I kind of have to make do with what I've got. And at the time, yes, I had the couch, the fridge, the chairs, absolutely outside the front house. And I was outside when Amy pulled up. And I said, oh, okay, I need to fix this. The nightstand in the back, again, it's another thing where, again, I just don't have transportation. Moving anything larger that can
It
fit
looks
in there.
like the nightstand's made out of wood.
Yes.
I mean, I'll tell you, I've cut up desks and nightstands with axes before, you know, and put them in garbage cans myself that way. So, had you considered something like that, or I mean?
Not till now.
Okay. How much time do you need to I mean, there's really not a lot
No.
that needs to be done.
I just need to know exactly, is the car a problem? It runs and drives.
Well,
Well-
no. I'm not gonna allow that. So it's not at issue in this case.
Okay.
Correct.
I have a concern, it might be later on, I don't know, but we're only here on the discarded, the junk, the debris. And the testimony I've heard, and actually, I mean, it looks like the photos taken yesterday show that there's new stuff that wasn't there in the beginning, which is like, I guess like an office chair and some, you'd have to tell me, but there's a, tool chest, dresser in the back. I think that's what's at issue. Am I wrong?
Right, it's the nightstand or chest, whatever you want to call it, in the back, and then the chair that's obviously inoperable in the front. The tool chest obviously it's usable, so that's a usable item.
I don't know that okay, so the tool chest is not at issue?
It's not, because it looks usable to me.
It looks usable to me too. Okay, gotcha. I don't. Okay, yeah, the chair was there in the beginning. Okay.
Yes,
Okay.
yes, no, it was there. It's just falling apart.
Gotcha.
So the top bottom's gone.
How much time do you need to get rid of this stuff, or bring the property into compliance? I mean, you could bring it inside, and I think that would bring the property into compliance, wouldn't it? If you bring the chair and the dresser inside.
That is something that if they're not there on the property, I'm not going to tell them to bring them inside, but if they're not
Well,
there
no,
on
what
the
I'm asking is
property-
that's a way to bring the property into compliance, isn't it?
Yes.
Okay. You see how simple that is? You don't even have to put it out for trash.
Right.
Okay, so how much time do you need to bring your property into compliance?
30 days.
I think you need 30 minutes.
I about to
But
say,
I'll
I
give
don't
you.
know what the minimum is, to be honest.
I'll give you, but
Whatever minimum time is
what's
allotted, I'm not sure.
right? Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the Special Master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I mean, we're laughing about this, but this is a complete waste of everybody's time. Okay.
I'm aware of this.
All right. So your property is found to be in violation. I have to grant you 30 days
Whatever minimum is.
from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on your real or personal property, as well as that of your father's. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and you will be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Good
Okay.
luck.
Thank you.
Next case today, David and Diane Parrish, case number 2130660, Code Officer Matt Hampton, page 17 of your agenda.
Mr. Parrish? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And please state your name for the record.
David Parrish.
Thank you, sir.
Thank you, sir.
Morning again.
Morning.
Matt Hampton, Citrus County Code Compliance Officer, case number 2130660, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 6614 West Beaumont Lane, Homosassa, Florida. The property owner is David A. and Diane J. Parrish. Have good service via posting of the property in the Lecanto Government Building. I would like to authenticate the documents and request that they be admitted into evidence. Exhibit A is photos I took during my initial inspection on June 14, 2021, photos I took for the corrective action inspection August 25, 2021, and photos I took during my final inspection September 14, 2021. Exhibit B is a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit and picture posting completed on September 2nd, 2021.
Mr. Parrish, you've probably heard me say it to some others, but I'd like to ask you to take a look at these documents and let me know if you have any objection to them being used as evidence in this hearing. Take your time. And I will give you a chance to talk about the photos. I just want to know if you have any objection to them as they are.
What time did you come yesterday?
It-
Ah, see, they did that to me.
It'll show on the photos, probably.
Yeah, you missed. Yeah, see right there, there's a dumpster standing right now. All right. Yes, no, I don't have no
Okay.
complaint.
And you have another document in your hand, or
No, that's just receipts from the landfill.
Okay, all right.
Yeah, I took
Keep
off
those for now. Keep those for now.
1,200 pounds I took off Monday.
Sounds good.
Yeah,
So, Mr. Hampton, I'm not hearing any objection for exhibits
No,
A and
no
B. I'd like
objection.
to see these documents if I can.
Because it's all gone.
Is anyone from the public here to speak on this case? Let the record reflect that there is no response.
It's being taken care of.
Okay.
Yeah. I've been scared to go anywhere with this COVID.
You and a lot of other
Yeah,
folks.
in the rain, so hey, we're getting there.
All right. Without objection, what's been proposed as exhibits A and B are evidence.
I conducted my initial inspection June 14, 2021, and I observed the property to be in violation of junk. There was a large collection of household garbage and other junk and debris around the property. I had contact with an individual one day at the property, but it was a kind of yelling from the porch to the vehicle type of thing. Conducted a corrective action inspection August 25th, 2021, and appeared to have more trash added to the piles. Notice a hearing was issued August 25th, 2021. As of my final inspection on September 14th, 2021, the one trailer with trash had been taken away, but they still had multiple piles remaining.
All right, Mr. Parrish, now tell me what's going on.
Well, there's a dumpster sitting there where he took the picture on yesterday. Yeah, so we're getting there.
Okay. How much time do you need to?
They gave me a month for the dumpster, so.
Right. Okay.
I mean.
So in 2 months, you can guarantee.
Oh, yes.
It's all going to be gone.
Oh, yeah.
Okay.
Okay. 2 months is plenty.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requested a special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that a special master additionally find that it is the respondent's responsibility to contact Code Compliance Division when the violation is abated in order to allow for reinspection.
I adopt the county's proposed findings of fact and law. The property is found to be in violation. Mr. Parrish, you are granted 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on your real or personal property. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record within 3 months of recording. And you will be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Now, I didn't need to see your receipts
No.
because
Okay, that's
I
fine.
believe you,
Yeah.
and you've accepted and agreed that the property will be fixed within
Okay.
60 days. So,
Good deal. Good deal.
yeah. Thank you.
Thank
All
you.
right. Oh, I can't go very far without that.
Nathalie Ray, Corey Hollis, Andrew Hollis, Laura Gilmore, Paul Hollis, Terry Hollis, Joan Hollis. Case number 129498, Code Officer Amy Becker, page 19 of your agenda. There's also another case numbers 2145310 against the same group of folks. Amy's going to be the code officer, and it's page 20.
Do you want me to do them both at the same time then?
I'd prefer it.
Whatever you prefer.
No, not necessarily. If it's
Whatever
not
you
an
prefer.
obstacle to
No,
you,
no,
then
it's not. It's not.
Okay.
Thank you. Okay, Amy Becker, Co-Compliance Officer. Case number 2145310, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. Also case number 129498, abandoned, unserviceable, and unlicensed vehicles, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 4, Section 20-41. The address for both is 229 West Casarina Place, Beverly Hills, Florida. Property owners Natalie Ray, Corey Hollis, Andrew Hollis, Laura Gilmore, Paul Hollis, Terry Hollis, Joan Hollis, Francis Newbuyer, and Mary Ann Hollis. I have good service for both cases via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A for both cases. Photos taken on July 13, 2021, photos taken on July 30th at my corrective action inspection, and photos taken on my final inspection September 14th, 2021. Exhibit B for both cases. A copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt signed for on August 9th, 2021.
And these are the same exhibits for both cases?
No, I have a couple more for the grass so you can
Okay.
see the...
All right. Is there anyone from the public who wishes to be heard on this case? Okay, then I'll make sure to call you all up. All right. Then you raised your hand. Do you have any reason to object to these photos being evidence in this case? No. Okay. Without any objection from anyone, what's been proposed as Exhibits A and B in both case numbers, that is 129498 and 2145310, are admitted as evidence.
On July 13th, I conducted an inspection for excessive growth and accumulation of vegetative matter and observed grass in excess of 18 inches at the property, which is a clear violation of the ordinance listed above. I also observed abandoned, unserviceable, and unlicensed vehicles, a blue and white van with an expired tag, and a black trailer with no tag visible. As of my final inspection on September 14th, 2021, the blue and white van remain with an expired tag, and the black trailer remains with no tag, and the grass has been mowed in the front and the side. However, there's an accumulation of vegetation in the black trailer. I have had contact with one of the owners, Natalie Ray, on August 4th and advised her of the violation.
What was the owner's response?
She said, okay. I mean, I told her, I said, sorry about that.
No, I
She said that
that's a lot of thought
I advised
to
her of
go
the
into-
violation, and I told her that there's going to be an upcoming hearing.
Yeah.
So this case originally, if you'll notice, one of the code numbers is older, the
Yeah.
129, because Leonard Hollis originally owned the home. He's deceased, so the family's now involved in trying to clean up the property.
So the reason why there's so many names is because it's inherited property.
Yes.
Okay. I mean, do the current owners understand they're the owners?
Yes, they
Okay.
know. I mean, they're very well aware that it's in the property appraiser has the new owners listed, and well, Natalie was aware. So
Okay.
they did mow. So they did mow the front and the side. They have a privacy fence on the back. When the doors open and I have access to the neighbor's property, I can view the violation. When it's closed, obviously I can't because I can't open the, so I still have the violation of the grass because of the vegetative matter in the black trailer, and I still have the van and with the expired tag and the black trailer with no
Well,
tag.
so you said the owner said okay, but I mean, did they indicate any willingness to fix the problem?
Well, their willingness was they mowed the lawn,
Yeah.
so I just assumed they'd be, I don't know if it's litigation, I mean, I'm not sure of the reasoning why.
Okay. I'd like to invite members of the public who wish to be heard to come on up, and I'd like to hear from you. You sure waited a while. What do you think? Should we televise these hearings? Do you think we'd get ratings? Do we just-
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your name, please, ma'am.
Cindy Burke.
Thank you very much.
My husband Bill and I live at 243, which is right next door to this property. I've been a nurse for almost 50 years, and we bought this property online. It's a beautiful neighborhood, except for this property. The owner did come and mow once. However, in the backyard, there is a huge fence, thank you, that I don't have to look at it, but you can look through the slats from our property. There is a pool back there that is filled with green slime water, and when I say filled, I mean up to the top. There are rodents going around in the yard.
Is someone living in the property?
No.
It's uninhabited.
No, it's uninhabited. We're now experiencing mosquitoes because of the pool. As we go into our backyard, behind where the fenced-in area is, right behind the yard, is like, I guess it's the county easement area. There's also a pickup truck parked back there that's slowly disintegrating into the ground. Our biggest fear is just that there are rodents in the house that are going to start coming onto our property. Like I say, they did mow once, but that was it. And it's the eyesore of the neighborhood. And we just moved here in June, so it's like, oh my goodness.
Yeah. Well, welcome. Where did y'all move from?
Philadelphia.
Oh, you made the right move. You made the right move.
Yeah, I think so.
Okay. Well, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the Special Master additionally find that it's a respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection. On both let me clarify, and that is for case 129498 and case 2145310.
Got it. I haven't heard any testimony about an imminent threat to public health or danger based on the rodents or otherwise, but if you guys do believe that that is an issue, you will want to contact the county, about that, okay? Once you start getting into rodents and a pool like that, there could be issues later on. I'm not your lawyer. I'm just saying that that's a separate deal, and normally there's more severe consequences as well, and the county may be empowered to take action. I don't know. So in any event, I adopt the county's proposed findings of fact and law in both cases. The property is found to be in violation. In each case, I will grant 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. That's for each case. This fine will be recorded and will constitute a lien on the real or personal property of the owners. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. That's it.
Thank you.
Thanks.
The next case, actually two cases, Marjorie Robito. Case numbers 214-3362 and 214-3364. Code Officers George Pearson, pages 21 and 22 of your agenda.
Good morning.
Good morning, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir.
My name is George Pearson. I'm with the Citrus County Code Compliance Division. I'm a Citrus County Code Compliance Officer. Case numbers presented today are 214-3362 and 214-3364. They are junkyard conditions and unlicensed vehicles. A violation of Citrus County Code of Ordinance, Chapter 20, Article 3, Section 20-31A, and Chapter 20, Article 4, Section 20-41. The address is 8916 East Island Drive, Inverness, Florida, 34450. Property owners Marjorie Robito. The service was good through certified mail receipt. I would like to authenticate and request the following be entered into evidence. Exhibit A, photographs that I took on June 16th. The photographs depict the violation of junkyard conditions on unlicensed vehicles. Exhibit B, copies of notice of violation, notice of hearing, and certified mail receipt. And Exhibit C, photographs that I took on September 14th, 2021. Photographs depict the property to still be in violation of junkyard conditions and non-licensed vehicles.
Is there anyone from the public who wishes to be heard on these cases? Let the record reflect that there is no response.
No, thank you.
And without objection, what's been proposed? Okay. Got it, thank you. What's been proposed as exhibits A, B, and C on each case are admitted as evidence.
I conducted an inspection on June 16th, 2021. 2021, I observed a violation of junkyard conditions and unlicensed vehicles. I spoke with the property owner's son several times over the course of the investigation, including yesterday. So I'm surprised he or his mom is not here. A notice of violation was issued for each of the violation on July 15, 2021. A notice of hearing was issued on August 19, 2021. A final inspection was conducted on September the 14th, 2021, and the violation of junkyard conditions on unlicensed vehicles were still present. I have notified him of everything that needed to be removed, and although there was a substantial improvement to the property, it still had junkyard conditions on it. And there was substantial improvement for the unlicensed vehicles. There was only one unlicensed vehicle there. But during my final inspection, I told him that, and he knew throughout the entire thing, all the vehicles had to be removed or shielded from view.
Okay, what's the county's recommendation?
Citrus County Code of Compliance Division respectfully requests that a special master assess a fine of $50 per day per violation, along with the administrative costs to begin after the date you deem sufficient to abate these violations. The amount was selected based on the actions of the property owner once they were advised of the violations. The amount is appropriate given the severity of the violation and respondents' actions relative to this violation. We would also ask the special master to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact and law. The property is found to be in violation in each case. In each case, the property owner is granted 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day shall be assessed, and that's for each case. This fine will be recorded and will constitute a lien on the real or personal property of Ms. Robito. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you, sir.
Thank you.
All right, the next case is case numbers 214-5538 and 214-8302. Jerry W. Audis, Code Officers J.C. Charlton, pages 5 and 6 of your agenda.
J.C. Charlton, Citrus County Code Compliance Officer. Case numbers 214-5538 and 214-8302. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A, and unlicensed and inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 161 North Mesquite Point, Crystal River, Florida. Property owner Jerry W. Otis. Excuse me. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during my initial inspections on July 19th and August 3rd, and corrective action inspections on August 3rd and August 16th, and my final inspection on September 14th, all of 2021. Exhibit B, the notice of violations, notice of hearings, and a copy of the signed certified mail return receipt for both cases.
These are two sets of evidence?
Yes, sir.
Okay. Is there anyone from the public who wishes to be heard on this case?
For the record, I just want to state that it's Lecanto, not Crystal River.
Sorry, Lecanto, yes. Thank you.
Nice, okay. Yeah.
Very good.
I was asleep at the wheel on that one. Let the record reflect also that there is no response for folks who want to be heard, and what's been proposed as exhibits A and B in each case are admitted as evidence.
I conducted my initial inspection on July 19th, 2021. I observed an unlicensed car on the property. I received another complaint on the property on August 3rd of 2021 and responded to the property. While at the property, I observed a garbage bag near the garage. I've had contact with the property owner's daughter, who now lives at the home, and advised her of the violation.
And what did she say?
She stated that she would remove the vehicle or get it registered.
When was that conversation?
That was during the initial inspection.
Back in July?
Yes. As of my final inspection on the property, both the unlicensed vehicle remains on the property now with a car cover and flat tires, and the junk and debris also remains on the property and continue to pile up near the garage area. And there has been no contact with the owner in regards to the vehicle to verify that the tag is current now, but the tires are flat on the vehicle.
Here's my issue.
Yes, sir.
It's only on the junkyard conditions case. You issued a notice of violation on August 10th, and the photos I have from August 3rd, which would have been the basis for the notice of violation, show the pallets, the garbage bags, things like that. But I don't see those things in the later pictures. I see other things that have been strewn.
The corrective action inspection?
Well, they're a little out of order, but hold on, let me put them in order. Okay, so, I'm just talking about the junkyard, the exhibit. So, I see the pallets, I think that's, and I also see that bag. In page 2, is that a bag, probably some garbage bags?
Yes, this is garbage bags. That was a corrective action inspection.
Okay. All right, and then on September, yesterday, we see new stuff, right? But it doesn't appear. So let me ask you this. If all the stuff that you saw in the initial inspection and that was the basis for the notice of violation has been fixed, but they put a bunch of other junk on there, is it still the same violation?
The initial was when I didn't get this case until later, the junk.
I know. That's the only one I'm talking about. This one we're going to handle, but I need to understand. Here's my issue. If they fixed everything that was the basis for your notice of violation, you've put them on notice of it. They fix that, and then they put a bunch of other stuff on there. I'm seeing a bunch of nods of heads that that's still a violation.
Yes.
Why?
Because they've added more.
No, they took away.
Well,
It's different stuff.
I mean, it's different. I mean, if it's junk, it's junk. If they took one garbage bag but still brought on a pallet that's junk, I mean, it's, if that's what I understand that you're saying, if they took junk at garbage and then, but now they have a broken pallet, you know, you trade one junk for junk. I mean, you're right.
In the notice of violation under the to wit, it states household garbage, loose trash and debris, and miscellaneous junk and debris. That is the reason it states that is so that we're not indicating one black, specific items, one black garbage bag. All right, so if they take that, and if they remove that one black garbage bag but replaced it with 16 pallets, well, then we've got a different issue.
Right.
But because we use the ordinance for our to wit, the verbiage from the ordinance and our to wit, it covers.
You're putting them on notice. It's not necessarily the exact things, it's the condition.
Exactly.
Okay. I think that's persuasive. Let me just read the code section and wrap my mind around. I mean, it's just something I've thought of now, but I think that's pretty persuasive.
I think the first section, or first sentence of the section, it shall be unlawful for the owner or tenant to permit, cause, or have thereon any accumulation of junk, debris, rubbish, and things.
Which code section is this?
I'm reading this from the notice of violation.
It's 20 dash.
20-31.
Oh, okay. All right. I see. It shall be unlawful for the owner to any accumulation. Yeah. Okay. Well worded on this one. I agree. Okay. What's the county's recommendation?
Citrus County Code Compliance Division respect requests special master assess a fine of $100 per day for both violations. Along with the administrative costs begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondent's actions relative to this violation. We would also ask the special master additionally find that it's respondent's responsibility to contact the Code Compliance Division when this violation has been abated to allow for reinspection.
I adopt the county's proposed findings of fact and law. The property in each case is found to be in violation. In each case, the property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed in each case. This fine will be recorded and will constitute a lien on the real or personal property of Mr. Aldous. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you.
The next case, Sidney Cantor, case number 214-9012, Code Officers Amy Becker, page 9 of your agenda.
Amy Becker, Code Compliance Officer. This is case number 214-9012, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. The address is 204 South Fillmore Street, Beverly Hills, Florida. The property owner is Sidney Cantor. I have good service via posting of the property, as well as the LaCanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on August 18th, 2021. Photos taken on August 25th at my corrective action inspection. Photos taken on August 31st showing the posting of the property. and photos taken on my final inspection September 14th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response, and what's been proposed as Exhibits A and B are now evidence. Without objection.
On August 18th, I conducted my initial inspection for excessive growth and accumulation of vegetation and observed grass in excess of 18 inches at the property, which is a clear violation of the ordinance listed above. As of my final inspection on September 14th, the property remains in violation. I have not had contact with the owner.
Do you know if anyone's living there?
It's vacant,
Okay.
or appears vacant.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact and law. The property is found to be in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Sidney Cantor. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you.
The next case, Teresa L. Cummings, case number 2144298. Code Officer Amy Becker, page 10 of your agenda.
Amy Becker, Code Compliance Officer. This is case number 2144298. Accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 9155 North Carissa Way, Citrus Springs, Florida. Property owner is Teresa L. Cummings. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on June 29th, 2021. Photos taken on July 8th at my corrective action inspection. Photos taken on my final inspection September 14th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt signed for on July 14th, 2021.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response. What's been proposed as county exhibits A and B are therefore evidence.
On June 29th, I conducted my initial inspection for accumulation of junk and debris and observed a pile of household garbage in front of the home, which is a clear violation of the ordinance listed above. As of my final inspection on September 14th, I observed a tire freezer enclosed at the property. The property remains in violation. I have had contact with the owner and a tenant. Both are aware of the violation. I spoke with the owner and the tenant, Christina Bennis, who rents a room there, on July 8th, 2021. I advised them the trash must be contained. I gave the Christina Bennis my card and asked them to call me to contact when they were ready for inspection.
Have you had any further contact with either the owner or tenant?
On August 27th, I called the tenant and left a voicemail asking if they were ready for inspection. And then when I tried them yesterday, the number's disconnected, no longer working.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact and law. The property is found to be in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Teresa Cummings. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Thanks.
Next case, Tracy Fitzpatrick, case number 2146363. Code Officer Amy Becker, page 12 of your agenda.
Amy Becker, Code Compliance Officer. This is case number 2146363, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. The address is 12750 East Big Buck Trail, Floral City, Florida. Property owner is Tracy Fitzpatrick. I have good service via posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on July 27th, 2021. Photos taken on August 13th at my corrective action inspection. Photos taken on September 2nd, showing the posting of the property. And photos taken on my final inspection September 14th, 2021. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response. Therefore, what's been proposed as Exhibits A and B by the county are evidence without objection.
On July 27th, I observed excessive growth and accumulation of vegetation, grass in excess of 18 inches at the property, which is a clear violation of the ordinance listed above. As of my final inspection on September 14th, the grass remains in excess of 18 inches. I have not had contact with the owner.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the Special Master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact and law. The property is found to be in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Tracy Fitzpatrick. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
The next case, Dawn M. Messer, case number 2132133. Code Officer Matt Hampton, page 15 of your agenda.
Morning again.
Welcome.
Matt Hampton, Citrus County Code Compliance Officer. Case number 2132133, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 3229 South Anatole Way, Homosassa, Florida. Property owner is Dawn M. Messer. Have good service via posting of the property of the Lecanto Government Building. I would like to authenticate the documents requested to be admitted into evidence. Photos, Exhibit A is photos I took during my initial inspection, June 14, 2021. Photos I took for the corrective action inspection on August 25th, 2021. And photos I took during my final inspection, September 14, 2021. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, and a copy of the posting affidavit and picture of the posting completed on September 2nd, 2021.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is none, and therefore, what's been proposed as Exhibits A and B are introduced as evidence without objection.
I conducted my initial inspection June 14, 2021, and I observed the property to be in violation of the ordinance listed above. There was loose junk and debris spread around the property, discarded furniture, auto parts, and other miscellaneous debris. I've had no contact with the owner or anyone else with regards to this violation. I conducted my corrective action inspection August 25th, 2021. There was no change. Notice the hearing was issued on the same day. As of my final inspection, September 14th, 2021, there has been some progress towards cleanup. However, there still remains furniture, appliance, and other debris spread around right around the front steps.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requested the special master assess a fine of $50 per day, along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master find that it is the respondent's responsibility to contact the Code Compliance Division when the violation is abated in order to allow for reinspection.
I do adopt the county's proposed findings of fact and law. The property is found to be in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Don Messer. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. Don Messer shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you, sir.
Yep.
The next case, Mary Peters, case number 2148679. Code Officers Amy Becker, page 18 of your agenda.
Amy Becker, Code Compliance Officer, case number 2148679, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. The address is 18 North Jefferson Street, Beverly Hills, Florida. The property owner is Mary Peters. I have good service via posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on August 13th, 2021. Photos taken on August 20th at my corrective action inspection. Photos taken on August 31st, showing the posting of the property, and photos taken on my final inspection, September 14th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response, and therefore no one else being present to speak on behalf of the property owner. What's been proposed as Exhibits A and B are evidence.
On August 13th, 2021, I conducted my initial inspection for excessive growth and accumulation of vegetation and observed grass in excess of 18 inches at the property, which is a clear violation of the ordinance listed above. As of my final inspection on September 14th, the grass remains in excess of 18 inches. I have not had contact with the owner.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day, along with administrative costs, to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the Special Master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I feel like I'm on the Monotram, like at the airport. You know, I'm leaving Orlando, and I'm on the. I don't know when the next software upgrade.
Inside the vehicle.
Yeah, exactly. Yeah.
I get it.
Okay. It doesn't help me stay awake. I'm trying to keep my wits about me here. Okay, so the county's recommendation was $50 per day?
Yes.
Okay. I adopt the county's proposed findings of fact and law. The property is found to be in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Mary Peters. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. Property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
The next case, Jason R. Rocio, case number 2142596. Code Officer Matt Hampton, page 23 of your agenda.
I'm glad you said
Rocio.
something, because I was about to lose him out there. Good morning again. Matt Hampton, Citrus County Code Compliance Officer. It's case number 2142596, accumulation of junk and debris. It's a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5475 South Oldfield Avenue, Homosassa, Florida. Property owner is Jason R. Rocio. Have good service via posting of the property in the Lecanto Government Building. I would like to authenticate the documents and request that they be admitted into evidence. Exhibit A is photos I took during my initial inspection June 8, 2021. Photos I took during my corrective action inspection August 23, 2021. And photos I took during my final inspection September 14, 2021. Exhibit B is a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit and picture of the posting completed on September 2nd, 2021.
Is there anyone from the public who wishes to be heard on this case? We'll let the record reflect that there is no response, and with no one else present to challenge the exhibits, they're introduced as evidence without objection as A and B.
Thank you. I conducted my initial inspection June 8, 2021, and I observed the property to be in violation of the ordinance listed above. There is furniture, trash, and a lot of other miscellaneous junk and debris spread everywhere. I've had no contact with anybody with regards to this property. I conducted a corrective action inspection August 23, 2021. There was no change at all. Notice of hearing was issued August 23, 2021, and as of my final inspection September 14, 2021, there has still been no change and no contact.
To me, it looks better. You don't think so?
No, sir. The only thing it may look, why it maybe look better now is because the grass is overgrown, kind of obscuring some of the view of some of the objects that were there.
That might be possible.
It honestly, it looks like the house has been completely abandoned. There's broken windows. There's,
Okay.
you know, it just looks like they walked away from it.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine $100 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, and this amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation is abated in order to allow for inspection.
I adopt the county's proposed findings of fact and law. The property is found to be in violation. The property owner is granted 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Jason Rocio. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you, sir.
The next case, U.S. Bank Trust, N.A., case number 2145516, Code Officer Amy Becker, page 24 of your agenda.
Amy Becker, Co-Compliance Officer. This is case number 2145516, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. The address is 1117 North Lombardo Avenue, Lecanto, Florida. The property owner is U.S. Bank Trust. I have good service via signed certified mail return receipt and posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on July 16th, 2021, photos taken on July 30th at my corrective action inspection, photos taken on September 3rd, showing the posting of the property, and photos taken on my final inspection on September 14th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, and a copy of the signed certified mail return receipt signed for on August 26th, 2021.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response, and I see no one. What's been proposed as Exhibits A and B are introduced as evidence.
On July 16, 2021, I conducted my initial inspection for excessive growth and accumulation of vegetation and observed grass in excess of 18 inches at the property, which is a clear violation of the ordinance listed above. As of my final inspection on September 14th, the property remains in violation. I have not had contact with the owner.
What is the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the Special Master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Do you know when the bank became the owner? I mean, was this a foreclosure or something?
Actually, no, I don't. I called the 3-day notice that was on the front door by Lippman Law Office. I called them, and Hudson Homes Management is the management company. They did not respond. Lippman Law Office said they'd let Hudson know that it was in violation because it's the right side. It's like they're not mowing the entire property. So no, I do not.
Okay. Well, what's the county's recommendation? $50 per day?
Yes, sir.
Okay. The property is found to be in violation. I adopt the county's proposed findings of fact and law. Property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owners, let's say. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you.
The next two cases, Randall D. Worthington, case numbers 214-2492 and 214-2493. Code Officers Matt Hampton, page 25, 26, and 26 of your agenda.
Good morning.
Good morning.
Matt Hampton, Citrus County Code Compliance Officer. I have case number 214-2492. Abandoned unserviceable, and unlicensed vehicles, a violation of Chapter 20, Article 4, Section 20-41 of Citrus County Code of Ordinances. And case number 214-2493, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances, both at the address of 5894 South Greenfield Terrace, Homosassa, Florida. Property owner, Randall D. Worthington. I have good service via signed certified mail return receipt. I would like to authenticate the documents and request that they be admitted in evidence. Exhibit A for both cases is going to be photos I took during my initial inspection, June 8, 2021. Photos I took for a corrective action inspection, August 17, 2021. And photos I took during my final inspection, September 14, 2021. Exhibit B for both cases will be a copy of the notice violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt. And both, I have two separate sets.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is nobody. And therefore, what's been proposed as Exhibits A and B in each case are admitted without objection. Thank you.
I conducted my initial inspection June 8, 2021, and I observed the property to be in violation of both the violations listed above, the abandoned, unserviceable, and unlicensed vehicles, as well as accumulation of junk and debris. For the vehicles, I observed one vehicle that had its hood up, appeared to be inoperable, and then one back by a bunch of junk on the left side of the property. For the junk and debris on the left side of the property, there was household garbage, scrap metal, miscellaneous junk and debris, auto parts. I have had contact with the property owner. He said he intended to get everything cleaned up. I conducted my corrective action inspection August 17th. There has been some progress still, but a bunch of scrap for the junk and the vehicles hadn't moved at all. Notice the hearing was issued August 17th, 2021, and as of my final inspection September 14th, 2021, there has been more progress towards cleanup. However, there are still some scrap metal and junk, and the vehicles remain in the same position, hood still cracked, and both appear inoperable.
You say the hood is cracked?
Like,
Oh, it's up. Yeah.
Sir, excuse me, sir. Yes, sir.
That's okay. Did the property owner say that the truck was inoperable?
During our conversation, he said he needed to get them fixed. That's why in the initial picture you look at, the hood was completely up.
Right.
It appeared to have been working on. He said that they needed to be.
The hood was up, and
Yeah.
then it was a little bit lower in the following photos.
Yes.
The code section says that otherwise unused vehicles as well. So
And with that, excuse me, I'm sorry.
yeah, go ahead.
I was just going to say with that part of the code, neither one of those vehicles has moved an inch. If you look in the picture, I mean they've stayed in the same spot every single time, which shows that they've not been used.
All right, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that a special master assess of a fine of $50 per day per violation, along with the administrative cost to begin after the date you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violations and the respondent's actions relative to these violations. We would also ask the special master additionally fine it as a respondent's responsibility to contact the Code Compliance Division when the violations have been abated in order to allow for reinspection.
So what does he need to do to bring the vehicle, case number 214-2492, into compliance?
The vehicles, they have to be appear operable with the hood cracked and open up. That doesn't, it appears.
So if he puts the hood down and moves the car 6 inches, I'm being serious. I
No,
mean, will that bring it into compliance?
Technically, it could. Yes, sir.
Okay. I adopt the county's proposed findings of fact and law in both cases. The property is found to be in violation in each case. The property owner is granted 60 days from today to abate each violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed in each case. This fine will be recorded and will constitute a lien on the real or personal property of Randall Worthington. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you.
Was that it?
That is all.
Oh, okay. Then in that case, the time is 11:40 and this hearing is adjourned.